Rules of Court, Part 4, Revised Rules on Evidence as amended. Rule 128, Section 1, Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceedings the truth respecting a matter of fact. Again, evidence is the means sanctioned by these rules of ascertaining in a judicial proceedings the truth respecting a matter of fact. Section 2, Scope. The rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by law or these rules. Section 3, Admissibility of Evidence. Evidence is admissible when it is relevant to the issue and is not excluded by the Constitution, the law, or these rules. Section 4, Relevancy, Collateral Matters. Evidence must have such a relation to the fact in issue as to include belief in its existence or non-existence. Evidence on collateral matter shall not be allowed, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Rule 129. What need not be proved? Section 1. Judicial notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of states, their political history, forms of government, and symbols of nationality, the law of nations, the Admiralty and maritime courts of the world and their asils, the political constitution and history of the Philippines, the official acts of the legislative, executive, and judicial departments of the national government of the Philippines, the laws of nature, the measures of time, and the geographical divisions. Okay. Section 2. Judicial notice when discretionary. A court may take judicial notice of matters which are of public knowledge or are capable of unquestionable demonstration or ought to be known to judges because of their judicial functions. Section 3. Judicial notice when hearing necessary. During the pre-trial and the trial, the court motu proprio or upon motion shall hear the parties on the propriety of taking judicial notice of any matter. Before judgment or on appeal, the court motu proprio or upon motion may take judicial notice of any matter and shall hear the parties thereon if such matter is decisive of a material issue in the case. Section 4. Judicial admission. An admission, oral or written, made by a party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not in fact made. Rule 130. Rule of admissibility. A. Object or real evidence. Section 1. Object as evidence. Object as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. Letter B. Documentary evidence. Section 2. Documentary evidence. Documents as evidence consist of writings, recording, photograph, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Number 1, original document rule. Section 3. Original document must be produced must be produced. Exemption: when the subject of inquiry is the contents of a document, writing, recording, photograph, or other record. No evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedure. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. D. Kunin mo muna naman. The original is a public record in the custody of public officer or is recorded in public office. And E. That the original is not closely related to controlling issue. Section 4. Original of document. A. An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. B. A duplicate is a counterpart produced by the same impression as the original or from the same metrics or by means of photography, including enlargement and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. C. A duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as to the authenticity of the original, or 2. That in the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. 2. Secondary evidence. Section 5. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution or existence and the cause of its unavailability, without bad faith on his or her part, may prove its contents by a copy or by a recital of its contents in some authentic document or by the testimony of witnesses in the order stated. Section 6. When original document is in adverse party's custody or control. If the document is in the custody or under the control of the adverse party, he or she must have reasonable notice to produce it. If, after such notice, and after satisfactory proof of its existence, he or she fails to produce the document, secondary evidence may be presented as in the case of its loss. Section 7. Summaries. When the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the fact sought to be established is only the general result of the whole, the contents of such evidence may be presented in the form of a chart, summary, or calculation. The originals shall be available for examination or copying, or both, by the adverse party at a reasonable time and place. The court may order that they be produced in court. Section 8. Evidence admissible when original document is a public record. When the original of a document is in the custody of a public officer or is recorded in a public office, its content may be proved by a certified copy issued by the public officer in custody thereof. Section 9, the party who calls for document not bound to offer it. A party who calls for the production of the document and inspect the same is not obliged to offer it as evidence.